going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy hump day. Happy Wednesday. Halfway through the week. 2 days left. I guess that means we're more than halfway through the week. Anyways, hopefully you guys have had a great week. All right, you guys want to watch some court? I want to watch some court. Let's watch some court. I've got a random collection of things tonight. We got some Karens. We got some idiots / court geniuses. You know, all the fun stuff. We're going to start with Judge Simmons. Yeah, that's all I'm going to say. Let's go. Before I hit that play button, you know what to do. Hit the like and subscribe to your Jump Kick Backflips. Let's go.
Your own base is fine. AJ just logged in.
Mine's is fine. Let's see. Pacific Flats versus Joshua Johnson, 25-00686. Appearance, please.
Good morning, Your Honor. Assumption Hart, P69542, on behalf of Plaintiff Pacific Flats.
Your name, please, sir.
Your name.
Joshua Johnson.
Okay, and he's present in the courtroom. Today was the date scheduled for a motion to enter judgment.
Correct, Your Honor. This is plaintiff's motion for entry of judgment pursuant to MCR 4.201K1B. Your Honor, defendant has failed to file an answer in accordance with Michigan Court Rules 2.108A1. He did file a jury demand, however, on March 14th and an unintelligible counter complaint on April 1st. However, he's failed to file an answer, affirmative defenses, or present the court with any triable issue to move forward with the jury trial that he is demanding. I do have outstanding rent right now, Your Honor, at $3,942.17. In addition to court costs of $174.95, I'd be asking for a judgment from the court for a total redemptive amount of $4,117.12 with a pair vacate date of May 9th, Your Honor.
Okay, I see here. Let me see what the defendant actually filed. March 20th. I see it says complaint, counter complaint. Reason, $3,020 for the money they stole December 2025 and before to November 2023. 274717. All the illegal and misappropriation must be.
C-Rex, thank you so much for the $5. I appreciate it. I can't tell if that's a super chat or a super sticker. I'm going to guess super chat. Thank you. I appreciate it.
Not supposed to be misappropriation of funds from January 2025 and beyond to March 4th. $5,000 for intentional infliction of emotional distress and ongoing harassment for a total of $10,767.17. Where's your answer?
My answer, when I talked to the county clerk.
No, when did you file your answer?
When I filed my
Did you file an answer?
I don't know if any answer.
You don't have an answer? You don't have an answer? Is that what you're telling me? Yes or no? Do you have an answer, yes or no?
Yes.
You filed it when?
I asked the courts to do what I needed them to do.
No, that's not what I asked you. The courts doesn't do what you need them to do. That's not how this works. Don't talk over me. When you are served with a lawsuit, which an eviction is a lawsuit, it tells you on there that you need to file a response and how many days you need to do that for. And so I don't see where you filed an answer. That's what I'm asking you. If you filed one, when did you file it? And you're telling me you did not file an answer. Only thing you filed was a counterclaim, which I agree makes 0 sense.
Your Honor, okay, the last time that was in here, I had spoken with their attorney, and there was a sheet that was completely different from the one that I had filled out, and I wanted to be sure that.
Yeah, he can miss his he can miss his procreation in the corner. Oh, I don't know if that was you know, what am I trying to say? You know, when you not spell check, but when your phone just automatically changes something for you, and he misspelled misappropriation so bad that it was auto corrected to misprocreation. It's funny though.
It was the same exact thing because there are a lot of discrepancies.
I don't know what you're talking about. What do you mean there's a sheet different than what you filed? You filed an answer that I just
Please,
read, correct?
Please, Your Honor, can I find that particular?
No,
sheet?
is it the sheet that I just read to you?
I don't know. It had a lot of letters and numbers on it.
That you
and it was
filed?
something that we had agreed on, the attorney and me had agreed on.
It was this attorney?
No, it was a guy. It was a guy.
You entered an
The
agreement
last
with
time we were
someone?
here on April 11th. We were here on April 11th.
You entered an agreement with someone?
They told me that they were telling me that they were trying to sue me for my part for the rent. I told them that I had proof that they had actually violated the contract and that they had stolen money from me. And that's what we had agreed on.
No, you didn't agree on anything. When you were here on April 11th, it was a pretrial. You did a joint pretrial statement, which I had, and you had issues with signing it. I don't even think I had. I think that there was a concern, or you didn't want to sign the joint pretrial statement. I had to bring you in here on the record, and then I went over it. I entered my signature, and I set it for case evaluation and mediation. So we're not talking about that. That is a standard form that the court uses to set deadlines. I'm talking about an answer to a complaint. If you're suing someone, you must, if someone sues you, you must file an answer to that complaint. And that answer essentially will explain whether or not you agree or you disagree with what they're suing you for.
I disagree with
No,
that.
I didn't ask you that. Did you file an answer?
I don't know if I did or not.
I don't see
don't
that
know
you
if I
filed
did.
one. Okay, I don't
must
think,
not have.
okay, I don't
Oh
see
my
that you
God.
filed one.
I'm scared.
I do see that you have filed what is named as a counter complaint. The counter complaint doesn't make any sense. It does not reasonably place the other party on notice as to what you're even suing them for.
Can I say
You
what
can
I'm
respond.
Okay, the reason why I am doing this, why I'm suing them, okay, is they have altered the ledger. Their ledger has been altered from my original ledger, which I have both copies of for you, for Pacific Flats, and for myself, that show in black and white that they have changed numbers in this ledger. And that they're also, they changed, okay. Let me,
I understand what you're talking about. Today's not the date that you're gonna show me any evidence because there's no trial going on here and there's no evidentiary hearing. This is a matter of whether or not I need to dismiss this case because you failed to file an answer. That's what this is for.
I had no idea. I am doing all of this all on my own. The only help I've had is from a landlord for 25 years. Is the only help that I've had whatsoever. They are not, Pacific Flats are not even allowed to sue me. It's in the contract. They are not even allowed to sue me for this,
Sue you for what?
for the back rent, because they are the ones that broke the contract. And I have all the proof.
Are you residing in the property?
Yes, I am, because.
And you don't believe that they can sue you for past due rent?
Because it's in the contract that they broke the contract. Pacific Flats broke the contract by failing the inspection back in June or January 24th, 2025. They failed the inspection.
You're saying that they don't have a rental certificate? Is that your defense?
What I
Do
am
they have,
saying.
is that your position, that they don't have a rental certificate? Just yes or no?
I don't know what that is.
Well, you said they failed an inspection.
They failed an inspection from Lansing Housing Commission.
Okay,
That's who they failed it with twice. They failed it twice, and
Okay.
they had not fixed but only 2 things out of the 11 items that needed fixed.
okay, so you're on section 8,
Yes,
and section 8 pays a portion of your rent?
yes, they do.
Okay, and have they been paying the rent?
They paid February's, but again, in Pacific Flats Ledger, they showed they didn't pay, but they did pay it. 'Cause I have
Okay, so
proof they
you
did.
have issues or discrepancies with the ledger, but your
Yes.
rent is paid by, or a portion of it at least, is paid by Lansing Housing Commission.
That's right.
Okay, and have they stopped paying your rent?
They stopped paying the rent to Pacific Flats as of March 1st.
So they have not paid anything since March 1st?
That is correct.
Okay.
They told me as
Now-
well to put my portion into escrow until these repairs have been fixed.
Got it. This eviction was filed in January, before they stopped paying the rent.
January. That's the thing. You see, there is no way that they could possibly even do that because they took that $1,300.
Well, I don't know what they took, because we haven't had,
That's
we haven't
where
we
I
haven't had a
got it.
trial yet.
That's where I gotta get to.
Before you can get a trial, you gotta follow the court rules.
Hitchbot, I can catch you up in faster than 2 times speed. So this guy is being he's being evicted. The landlord wants him out for non-payment of rent. But as we just heard, there's a little bit of twist in this. He's on Section 8. Wait till you hear how much he pays in rent a month. It's sometimes I get sick when I hear how low some people pay in rent. But anyways, that's another conversation. But because the landlord failed an inspection, Section 8 stopped paying. So so he's being evicted for non-payment, but he's claiming that the landlord broke the lease agreement because they failed an inspection and got the Section 8 canceled. He's got a defense, but he needs a lawyer. But he clearly can't afford one. He wouldn't be on Section 8 if he could afford a lawyer. But yeah, it's an interesting case.
So I am going to give him 7 days to file an answer.
Yes.
Motion for entry of judgment is denied. He's not represented by an attorney. He did obviously appear to our clerk's office for assistance with filing his counterclaim, but maybe they didn't know that he should have filed an answer because this was a landlord-tenant matter. He appeared obviously for the pretrial. It was set for a hearing. Typically, we wouldn't have an answer filed in a landlord-tenant matter. But he's now having a counterclaim and wants to proceed to a jury trial and proceed as in normal litigation. So you now need to file an answer, and the answer needs to comport with the court rules. So you might need to get a book that has the civil court rules, or you might need to Google it. But it needs to make sense, sir, okay? I'm not saying that it needs to be filed as if you're an attorney, but you have a copy of your complaint, correct?
Yes.
You're only responding in your answer to their complaint, what they're alleging, which is that you have failed to pay the rent. They're demanding possession for the non-payment of rent, okay?
Okay, so all I have to do is tell them why I do not owe that rent.
You can
And that's
put
it.
your lawful, what you believe are your lawful defenses to withholding the rent,
And
absolutely.
that is it, and that's all I've got to
And
do.
you need to file it with the court and serve them with a copy.
And serve them, which means register mail, correct?
That's correct.
Okay, so all I've got to do is file with it.
That's all you're doing, because that's on, as it relates to this.
Okay, and then we can go to jury trial.
We're-
We can
and
go
we're-
ahead.
Yeah, we don't know. We don't know what his story is though. Yeah, no idea. No idea why he is. He might have a legit reason to be on assistance. I don't know. Maybe he's scamming the government. I don't know. It might be one of those. It might be somewhere in between. It might be neither of those. Who knows?
Get this all
That's
brought out
correct.
to light.
Unless
Okay.
a summary judgment motion is filed later, then we'll have another hearing. If you're filed with anything, I don't care if it's a motion or if you're filed with a lawsuit, you have to respond. You can't just not respond to it. So there may be a motion filed later. They may file and serve you with what's called a motion for summary disposition. If you get that and you don't respond, they can come back and request default judgment against you again because you're not responding.
Okay, Your Honor, this is the first time that anybody's mentioned that to me, so I thank you.
That's what I'm telling you.
I'm thanking you for doing That's the first time anybody's mentioned it to me. I appreciate that. Thank you.
Okay, no
I
problem.
will go and sign that today.
Okay, I'll give you 7 days to get it filed. Any additional matters for the record?
Okay, and then we
Counsel.
can go ahead and I serve them as well, and then I can get this set to jury and all this can come out to light. Okay.
Thank you. Counsel?
Yes, Your Honor, I'd ask for an escrow order to issue, Your Honor. The case was filed in January. We do have an outstanding balance of $4,000. I'm asking for the amount of $960 to be paid within 7 days and moving forward until the case is resolved.
Okay, and just for the record, is it true that Lansing Housing Commission has withheld the rent?
They stopped paying back in January, Your Honor.
Why?
I'm not sure. I do have a property manager present in the courtroom to address that from Pacific Flats.
I can't hear you. Can you speak a little louder?
Yes, it was a failed Lansing Housing Commission inspection that we were never notified of. We found out about after the second.
Okay. Can you state your name for the record?
Yes, my name is Sharice. Sorry, my name is Sharice Williams. I'm the property manager.
You can spell that, please.
Yeah, CHARISSA Williams, WILLIAMS.
Okay, so they're not, the Lansing Housing is not paying because of failure to have an inspection, or they didn't properly proceed with the inspection in some form. And that's not yet been resolved, correct?
We were denied entry until about 3 weeks ago, yes.
So you just had a inspection?
After the second inspection, I reached out to his case manager because we kept being denied entry. He would not allow us into the unit while he was not here, but he would get up and leave until my maintenance guys couldn't go.
Okay, so has there been an inspection or no?
Not a re-inspection, no.
Okay, so there was an inspection,
In January, yeah.
and so you've made attempts after learning about the failed inspection,
Correct.
so that you can get it re-inspected, but you've had some hindrances, you're saying, from the counter plaintiff / defendant, from being able to gain entry, but now you have a scheduled inspection?
No,
Okay,
we haven't scheduled the inspection yet. We had one last piece. We just had to replace the refrigerator. It was actually just delivered to my office this morning.
okay, so that needs to be done, and then you can schedule an inspection.
Right.
Okay, and you want an escrow order for his portion of the rent?
That is correct,
Correct.
Judge.
What is his portion or his monthly contribution to the rent?
Gotcha. Gotcha.
Judge, I believe his portion would be $800 if I'm not mistaken.
Is that correct, sir?
No,
No.
no, not even close.
How much is your monthly rent, sir?
Monthly rent is $12.
$12? Is that correct, ma'am?
I can't confirm it without looking in my
I
system.
can show you here.
Okay, I got one, he's telling me his is $12. You're telling me it's 800, these aren't even close.
Correct.
I know it's not 800.
And the property manager says she knows it's not 800.
Just a cursory look at the ledger, Your Honor. I don't see a $12 tenant portion. But Your Honor, if he is not allowing access to reinspection, I would ask for the $960 to be paid by Mr. Johnson.
It's not even ready for reinspection because the conditions haven't been brought up to code, it sounds like. It's one part that was just received today. Nonetheless, I do have a housing adjustment notification from November 15, 2024. It says that his total rent is $960 and his contribution is $12. Order of escrow for $12 per month will be entered. You need to put $12 from all the past 2 months into escrow at the court, okay, for each month.
I have escrow already, all the way
At
up
the
to
court?
February. I'm sorry, with MSU.
Okay,
And
and that's not escrow, it needs escrow at the court, okay? So you'll go down
Okay.
to the civil department and let them know you need to
Pay
put your money in
12
escrow.
Up to January then?
Yep, January, February, March,
and
April, and then May will come, you'll come and you'll put your monthly rent in there too.
Okay, yep, no problem, no
Okay.
problem.
Any additional matters for the record?
Nothing for
Now,
planning.
yes.
No.
I'm sorry?
Council, I do need you to provide me an escrow order to sign.
Absolutely. Your Honor.
You had something else?
Yes, as
Mo, it has nothing to do with I can't take health problems. I don't like putting people's personal issues on blast, so I don't bring them up. I don't mind you guys talking about them, but I don't like bringing them up and giving light to anything that's going on because it's personal, right?
far as this whole denying them entry into it, do they have any proof of this? Because
I didn't get into any of that.
But
did I?
they have to prove it, correct?
No, we're not, it's not an issue to be proved. I didn't get into it. You need to allow them entry, obviously, to get the things
Absolutely.
done.
Absolutely.
And you all
Always
can
have.
work through that. If it
Always
becomes an issue, council will file a motion to get it before the court if they believe that there's an entrance hindrance,
How can I
okay?
get them to not, how can I just tell them, go ahead? I'm telling you, go ahead. I have been telling you for months, go ahead, for years.
Okay.
Go ahead, Mr.
You're
Johnson.
all set.
That's
Thank
why I
you.
wanted to just.
Bye.
Thank you, Your Honor.
do it.
Bye, have a good day. Thank you.
Just confused. Just confused.
All right, I told you that one's interesting. He's got a defense. I mean, they failed an inspection, stopped paying, and I don't know. I mean, that's exactly how it would work. If Section 8 stopped paying, you would owe the entire rent because you owe the entire rent. It's what's on the ledger. Just Section 8 covers part of it. Interesting. I want to see how that case ends. I want to see if he wins. I mean, $12 a month. That's the part that was kind of made me sick a little bit. $12. I couldn't imagine. Yeah. Anyways, let's catch up on these super chats. Carla, thank you for the super chat. I hope everyone is having a good week. I am having a good week. I hope you are too, Carla. Thank you for the super chat. Phil, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Thank you, Phil. And Sparkle Poots. I love this community. Just saying, oh yeah, Colin, you're okay too. Yeah, I'm okay. I know. The community is what makes it though. I'm just here. I'm just facilitating. So I'm allowed to be just okay. You guys are the awesome ones. Thank you, Sparkle Poots. All right, moving on. What do we have next?
Hello.
Oh, this is a good one. You know what? I'm not even going to spoil it for you guys. It's good. It's good. Get ready.
All right. We've got all 3 of your people. Let's start with Valley. This is, we got something. This is 25 RO 1973. Zali, you were cited on the 6th day of April, 2:15 in the afternoon, Woodward and Buckingham, changing lanes without due care and caution. The options you have today are 3. You can admit responsibility or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Deny responsibility. Would I be able to speak to the officer in a breakout room?
No.
Okay. I would like to deny. I'm sorry?
This is the date and time set for the hearing.
Okay, I would like to deny responsibility.
You'd raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
Yes.
The officer will testify first.
Yeah, Your Honor, on April 6th of 2025 at about 2:17 in the afternoon, I was dispatched to a property damage accident or a traffic crash involving this Buick Encore driven by Miss Pizziali, is it?
Yeah.
During which it was found that she made a lane change over to the right in a lane that was occupied by another vehicle essentially sideswiping that vehicle. And at that time, both drivers had admitted to me the same thing of what had occurred.
Ms. Pizziali?
So there are a lot of things that happened during that situation that are confusing to me. I did turn onto Woodward going towards Buckingham, but I would say that I'm a very cautious driver. And when I made the turn, I did recognize that there was enough space between me and the cars, like coming, I'm not sure what direction, but coming toward where I was headed, for me to feel comfortable to turn onto Buckingham. As far as I know, I didn't like register that that car was separate from the pack or closer to me in any way. And he was behind me the entire time. When I was getting over into the lane, my turn signal was on the entire time. And my car has safety features that recognize that, like if someone's in front of me or behind me, or even in my blind spot, to like signal to me to stop or to not make that motion. And none of those signals went off at the time of when our cars hit each other. And so I'm just a little bit, I was, unaware that he was in where he was. And when we hit, my car was going this way and, his was coming this way. And I genuinely I don't know, like he was behind me the entire time until he wasn't. And then I'm not sure if he, was trying to get around me. He saw my turn signal on and didn't, I don't know how he got there, to be completely honest with you, because
Were you in one lane and were changing into another lane?
so I was turning from, I don't know the directions, but I was like in a turnaround, like right before Buckingham Avenue. And so I was, crossing over to get onto Buckingham. I'm not sure if that makes sense.
So you,
I wasn't driving like in the same direction as the man. I was in a
so
turnaround.
you're doing the Michigan left, so you went from one way on Woodward to the other way.
Correct. But
Okay.
Buckingham was like almost like right across from that turn. So I was just kind of like moving, like through the lanes with caution. And I'm not sure if he was trying to get in front of me or like trying to, pass me as I was, trying to get onto Buckingham. But I was aware of my surroundings. I had my turn signal on, and none of the signals in my car, told me to stop, and neither did anything that I had.
Oh, Sparkle, they're so confusing. Oh, I know Taylor has them on the main road. I think it's Telegraph. And you can't turn left at a traffic light, at a four-way stop. You can't make a left turn. Instead, about, I don't know, an eighth of a mile, probably 100 or 200 yards after the traffic light, they have a left turn for people that want to go that left. So if you want to go left on Telegraph, you can't go at the four-way stop. You have to go straight through it, turn left at a left only to turn back, go in the opposite direction, and then take a right. I'm guessing it's supposed to keep the flow of traffic going, but it is annoying if you want to take a left. Michigan lefts. I'm guessing that's what they're talking about, because that's the only state I've ever seen that in. Oh man, if you don't live in Michigan, it's kind of confusing. Not gonna lie. Every time I'm out there, I dread it. So it's like, I'm gonna mess this up. People are gonna honk at me. I don't like it.
Registered previously to make that turn.
Hey,
So I'm not
what about looking where you were going?
I was looking where I was going. I was, and
Did you see the car?
that is what is confusing. Like, I'm not sure, I don't know. He wasn't, I didn't.
Well, Scotty didn't beam him down.
I'm sorry?
Scotty didn't beam him down.
I'm not sure.
I guess I'm.
Oh, she didn't even get the reference. But no, Judge. I mean, where's your evidence of that? You don't know. Maybe Scotty did beam him down. We don't know where the car came from.
I'm dating myself with Scotty.
I'm sorry.
But the bottom line here is that there was a vehicle in the lane that you were going into that you didn't think was there.
Right, and I didn't see, like, he was in the, like, he was far behind me from what I registered for me.
And yet the two sides of the cars were in contact with each other.
So the front of my car, and the back of his car, so as I was like turning, I don't know, I guess, as I was turning, like my car and the back of his car kind of hit like this. And that was what, so obviously like it looks like my car hit his car, but he wasn't, like I had no, and I know it's hard for me to explain because it, like the way that our cars hit makes it look like I like totally hit him and I wasn't paying attention, but I know that not to be the case. And I had a passenger in the car.
Why do you think that's not the case?
Because I am a cautious driver, and I especially driving on Woodward, a 4-lane highway, does make me a little bit nervous. And I know that I would not, and I didn't feel comfortable turning until I knew that all of the cars, like until I felt safe enough to turn onto Buckingham without, getting in the way of other cars or other cars, cutting a little bit too close to me. I was waiting in the turnaround until I felt safe enough, and I did feel safe enough, and somehow he came and our cars collided. I don't know if he had maybe turned onto Woodward at like around the same time that I was turning onto Buckingham. I'm not sure. But
Would it matter?
He was not in my blind spot. He was not in front of me. He was far behind me for me to feel safe and comfortable enough. And the passenger in my car can agree to that as well. Like, and none of the signals in my car went off.
And when you're driving, you have a duty not to turn onto a road. You were coming out of the Michigan left.
Correct.
You have a duty to stay there at the stop sign until it's clear.
I agree. And that is exactly what I did.
No, it isn't what you did. If it would have been clear, there wouldn't have been a crash.
That is why I'm confused. And that's why we're here today.
What's confusing you is you seem to have eliminated the possibility that you goofed. You didn't see somebody that was there.
Well, I would agree with you on that, except for I had a passenger in the car, and they were also very, like, they also are aware and a very nervous driver, and they felt that they didn't see this car either. And so that is is even more confusing.
The car is visible.
Too. Right.
This is what, 2 o'clock in the afternoon.
Right.
The car doesn't have any cloaking devices. It's sitting there. It's 20 feet long. It's 6 feet wide. It's 5 feet high. It's visible.
Yeah. Well,
there would not have been a crash if you didn't go into that person's lane.
I'm saying that I don't think that this was my fault. I do know for a fact.
Are you blaming the other guy because he's driving down the road and happens to be in a lane that you want to turn into?
I do know for a fact that he was.
Do you blame him because he was where you wanted to be?
I think that this is a situation where maybe
Answer my question.
could have done better.
Are you blaming the other guy because he was physically present where you wanted to be?
I don't blame him because he was in that lane. I do think that I do know that he was behind me.
Yeah, absolutely, Lone Wolf. What no one knows is I am the one who beamed that car down. I saw her taking that Michigan left, and I thought to myself, I don't like Michigan lefts because I'm afraid every time I come up to one. So I'm just going to beam this car right down here and watch the chaos happen. And it was a slow court day, so I was just hoping to see this in court. And look, here we go. So Lone Wolf, it is my fault. You're absolutely right.
The entire time.
Ma'am, if he was behind you the entire time, the front of your car wouldn't have hit the back of his.
That's what I'm saying. I don't know how he got in.
You made a mistake. You didn't see somebody that was there.
It's
possible you could have made a mistake, and the crash is kind of a proof of it.
Well,
we all make mistakes.
I do know.
Why can't you admit that you hit a car that was there?
I am more than willing to admit that our cars collided and that I do make mistakes sometimes, but I do not think that this is a mistake that I made.
Well,
because
causing a crash is a mistake.
I'm
sorry. You didn't do it on purpose.
I'm sorry?
You didn't crash into the other car on purpose, did you?
I did not crash into the other car.
Therefore, you made a mistake.
I would say that I guess I know that it is a confusing situation in the way
that
confusing. Our cars.
There's nothing confusing about it. It's perfectly clear.
Your Honor, he was behind me the entire time.
Then how
And
did you hit the side of his car if he's behind you?
So I'm not sure if he was trying to get around me, but
Does
the
it
man
matter? He's
admitted-
got the right of way. You don't.
I'm not, I just, Your Honor, I am struggling. I've thought about this situation so many times, and I'm just struggling to understand really what happened. And I talked to the other passenger in the car, and she also is struggling to understand how that happened, because like he was behind me until he was.
If he was behind you, you wouldn't have hit the side of his car.
But he was aware that I was turning into the lane.
It doesn't
He
matter.
told me
You
there,
don't,
and
you're not parting the waters of the Red Sea with a turn signal. You
I
turn
understand that.
you turn your turn signal on. It doesn't tell people they have to get out of your way.
I understand that. The issue that I'm having is that when I turned onto Woodward toward Buckingham, I was very confident in the fact that I could get to Buckingham with having the cars that were coming, toward Buckingham have a lot of space where I wouldn't have even gotten even close to them. So that is what is confusing. I'm not sure if this man.
You're eliminating the possibility that you made a mistake. You didn't go until you were confident, but you were mistaken. If you would have been correct, there would not have been a crash.
And so that is what I initially thought as well, because I was like, this is a mistake that I made. But upon further reflection and talking to the passenger in the car with me, I realized that I really genuinely did not make a mistake. The car was with the pack of cars that I felt safe enough to turn in front of. I'm not sure if this man had seen me coming, saw my turn signal, decided to, get around me or get past me, and then
Which he has a right to do.
Happened.
First of all, you're making an illegal turn. When you make a left turn onto Woodward Avenue, the statute requires you to make the left turn into the left lane. Then you can change lanes, but you can't make the left into the second or the third or the fourth lane. When you make a right turn, you have to make it into the rightmost lane. When you make a left turn, you have to make it into the leftmost lane. The statute requires that. But that is kind of honored in the breach with the Michigan left set up the way they are. However, when there's traffic on Woodward proceeding in the way that you want to go, or if you want to cross them, whichever way you're going to look at it, they have the right of way. You have to wait for them. You didn't. There was a crash. You caused the crash. You're responsible for the civil infraction of making an improper lane change. This idea that upon reflection, you can't see that it was your fault flies in the face of the reality of the situation, that you felt confident you could go, you went because you were sure it was safe, and unfortunately, you were wrong. Fine is 170.
No, what I think she's trying to say is she doesn't want to blame the other driver, and I think that's what she's trying to do. I think what she wants to say is he was speeding. When I went to turn left, he wasn't there. I had enough room to turn, and then when I turned, I hit him. I think that's what she's trying to say without blaming him. That's what I got. But I think the judge just nailed his recreation. Is that she was trying to turn left, and instead of turning into the left lane, she went right into the middle lane. And I think that's exactly what happened. But yeah, we can't do that. I know everyone does, but you can't. Well, I shouldn't say can't. It's illegal. You'll get ticketed, just like she did.
It's clear that you're responsible. There's no ambiguity there at all. If the officer hadn't testified, if I heard only your testimony, I'd have to find you responsible. The fine is $175. It can be paid online or by mail. Or you could drop by the courthouse and pay it at the counter if that's more convenient for you. Thank you.
Okay. Thank you. Have a good.
We're good to go.
Oh, that one was fun. That one was fun. I don't know why. She just couldn't admit that she made a mistake. I don't know if, you know what, I'm not going to comment. Let's just keep going. Let's just keep going. What do we got now? Oh, this one's fun. Yeah. Don't lie to Judge Webster. Don't lie to any judge. Don't lie to anybody. Let's just say that. Don't lie. And if you're gonna lie, at least be good at it. This guy's not, because you can check things. He apparently thinks they're not going to check anything.
And 23 CR 20, State of Kansas versus Brandon Ray Jackson. Jill Gillette, County Attorney, still appearing for the state. Tony Bauer still appearing as CSO. And the defendant has now joined us, telling me that he had been given the wrong codes. So he appears about close to an hour late.
I
Now,
apologize, Ron.
well, sometimes things happen, but at least you're here, and I'm setting aside his bench warrant and no bond hold. But he's telling me, Mr. Bauer, that he's still inpatient treatment and that he
I
and that he's concerned about whether he can be here at a future revocation because of his current circumstances. Now, Mr. Jackson, did I say that wrong?
no, ma'am.
Okay. What I'd like to ask you, Mr. Bauer, is he doing inpatient as you know it?
As far as I know, he is not an inpatient. The last place he went, they sent a letter saying he walked out of treatment and left without being released, basically. So if he is an inpatient currently, his counselor should be sitting right there where we could speak with them.
Okay. Can you put your counselor on, please, sir?
My counselor, they're not with me right now, but I have the contact to call them right now. His name's Aaron.
What's
Eric
the name?
Schallenbach.
What's the name?
Eric Schallenbach.
Aaron or Eric?
Eric Schallenbach.
How do you spell Schonbach?
Schallenbach is spelled SCHELLENBACH.
All right. Where are you staying right now? What is that room you're in right now?
So where's the room?
Where are you?
I'm in the kitchen or whatever you can call it, dining room, and they.
Of what facility?
Oh, it's called Evoke Wellness, is where it's at, and I'll be starting at I've been admitted, so I'll be starting today.
Evoke Wellness is the name of the facility.
Evoke, yes.
And your counselor there is Eric Schallenbach.
Schallenbach.
And did you start to say you just started that today?
Yeah, I'll be admitted today. Be the first day today. Because I had the court hearing, and I was gonna have me go in person, but I got the Zoom meeting ID, so they and then the phone number for Mr. Schallenbach.
No, stop. I'm not gonna do that. Well, I ordered you to be present at the courthouse today, and you're not.
Yeah, they gave me the Zoom meeting ID, Your Honor.
I don't care whether you got the Zoom meeting ID or not, you were ordered to be here in person. So since you're not, and since so apparently you got kicked out of a treatment, although your attorney will argue that for you at the appropriate time. I'm going to leave the bench warrant no bond hold because you did violate my order. And then when you need to turn yourself into law enforcement today, don't get yourself admitted to treatment, get yourself to law enforcement. And then we'll get Mr. Paul in here and we'll see what we need to do about your future circumstances. But
okay,
I feel a bit of a manipulation going on.
Can you contact Mr. Schallenbach?
I'm not going to contact Mr. Schallenbach. If your attorney wants to subpoena him for a future hearing, that's fine. But I heard you say you hadn't been admitted yet. You're hoping to be admitted.
I am admitted.
Oh, you are.
Yes, I've been
Make
admitted.
sure you sign any and all releases, so you're.
Yes, I've signed the releases. I've done all this stuff. I have copies of the documents and everything.
Well, I'm ordering that you turn yourself into law enforcement and that there be a no bond hold, and we'll talk about this when you get yourself arrested and brought back into court.
Your Honor,
Yes, Mr. Bauer.
if I could inquire, where is the Invoc Wellness located at? Because I've done a Google search and the only ones I'm showing is Evoke, and they're out of Ohio and in that area.
You're not in
I'm not
Ohio?
finding an Invoc Wellness.
Invoke Wellness. I can send you the information to that.
Okay, spell the name of your facility.
I'm pulling the email up, Your Honor. Okay, and it's okay. Evoke Wellness. 1 second, it's loading.
Spell Evoke Wellness.
It's EVOKE Wellness.
And what's its address?
The address is, let's see here. Looking at the address here. Let's see, this is just the promissory note of, let's see. 1 second.
What town are you in?
I'm the town, the wellness center is in Texas.
You're in Texas?
It's in San Antonio.
You left the state. All right.
And Eric Schaumbach, and I have the
All right,
email.
before we proceed any further, we are proceeding on the bench warrant, bond forfeiture, and a no bond hold. Who's with you there that made a comment? Did I hear a woman with you, sir?
No, ma'am.
Okay, maybe she's in a different office. Okay. All right, anything further from anyone? Get yourself to law enforcement.
Okay, thank you.
All right. Thank you. We're adjourned.
Yeah. I don't think anything he said there during that entire hearing was true, except for his name. Who was that I just heard? What woman's voice? There is no woman. All right. Yep. Just like you're sitting in the dining room, kitchen area of a wellness center. Yeah. Anyways, I don't think he's going to turn himself in. The next time we're going to see him, he's going to be in orange in front of Judge Webster. Anyways, Wixom. Well, unfortunately, the next case I was going to come up there for was the Lindsay Dineski preliminary exam. But if you haven't heard, she took a plea deal. And she pled no contest. I didn't actually see what the wording was on the plea deal. All I could see is she pled no contest, and she is currently on probation for that case, for the assaulting of the police officer. She still has the case in front of Judge Washington and the case in front of Judge Triplett, which is the case with Chuck. And yeah, so I don't know. That's what I was gonna do though. That was the next time I was gonna go up, and I think that was scheduled for next week, or maybe even been this week. I don't know, but yeah. So I don't know. I guess I'm just gonna pick a random day. I am missing it. Let's see. Today's Wednesday, so I won't do it this week. Maybe I'll do it on Monday. Maybe that's what I'll do. Maybe Tuesday. No, Tuesdays are maybe Monday. Maybe I'll take a trip this coming Monday. I like that idea. What do you guys think? Trip on Monday? It could be fun. Okay, moving on. What is next? Oh, this one's more interesting and kind of funny. We have twins. We have twins that don't get along. I thought all twins got along. At least they don't really look like twins. I mean, I guess they don't have to be identical twins, but they do say that we're brothers and I'm 6 minutes older than him, and that's a very twin comment to make. Just saying. Okay, let's go. A twin evicting a twin.
How about Gordon McCain versus Brian McCain?
Yes, I'm here.
Look at you there. How about Brian McCain? Looking for Brian. No Brian McCain. And you're Gordon?
Yes, sir.
Okay. Do you have personal service on Brian McCain? Are the two of you related somehow?
Yes, we're brothers. I'm the older brother by 6 minutes.
Oh, okay.
Yeah, that right there. That's a very twin comment to make. I mean, yeah.
Do you have personal service? Why don't you raise your right hand there for me? Do you swear from the testimony you're about to give? Yep. Do you swear from the testimony you're about to give will be the truth?
Yes, sir.
Okay, you can put your hand down. Is this property you own at G3275 Augusta?
Yes, I currently do, but I'm fixing to lose it for taxes because I'm behind and I don't have the money to do it. I'm just trying to get him out of my house because he was evicted out of the one place he was staying at with a friend of his, a lady friend. Then he went to jail a few times. I went and got him. And then he just come over to my house. But I told him previously that I don't have the room, and then he just basically moved in. But then it's basically he's waking us up at the morning hours, yelling, screaming, and carrying on. And
Hold on, Mr. McCain, hold on just a minute. I guess I got you. He's on here. He just not near. Sir, do I have Brian McCain there too? Oh, you need to unmute for me. That's what's going on. I see your head nodding, but okay.
Hello, I'm here.
All right, this isn't relevant to the case, but it's relevant to the conversation on twins. I can't remember the actors' names, but the actors that played George and not even the twins from Harry Potter. Man, people are gonna yell at me for forgetting their names. Anyways, someone actually asked them during an interview a dumb question like, "How long have you been twins?" or something like that. It was the Weasley. Yeah, I know it was the Weasleys. Fred and George. Okay, Fred and George. Yeah, someone asked them, how long have you been twins? Something stupid like that. It was a dumb interview question, and they responded back priceless. And they said, "Oh, we're not twins. We actually met during auditions. It's crazy. It's hilarious." I love that they had that sense of humor to not embarrass the bad question. I mean, that was a bad interview question, or maybe it was designed to be funny. I don't know, but I love the answer.
Okay, so
how are you, sir?
I'm sorry, Gordon McCain. So this is property you own by yourself?
Yes.
Okay. And Brian McCain is, I guess let's start out there. Is that true? Are you just allowed on the property right now?
No, long story short, sir, he should be truthful with you and not raise his right hand. He no longer owns the property. He was 5 years behind the taxes. The Genesee County Treasurer actually owns the property since March 31st of this year. He should not have been down there applying for such. He doesn't own the place. The Genesee County Treasury does. I called down on Friday afternoon to let you know such. He's just been taking toxic, let's say.
So don't tell me too much yet.
He's just been taking poor advice been taking poor advice from family members, and one of them happens to be our stepfather, our adopted father, and I even have an admission from him telling Gordo to walk away from the house.
Don't tell me a whole lot yet, because we're doing it as a deep.
That's where I'm stopping. He doesn't own the property anymore, sir.
So Brian, hold on. You have a right to have an attorney present as well, or talk to somebody. Do you want to just proceed on your own? Is that what you're telling me? It sounds like it, but.
Yes, most certainly. I'm open to even say the conditional dismissal just the same, with seeing how he come down on 4/22 to file this. Never mind on March 31st, he's well aware that he doesn't own the property. The Genesee County Treasurer owns that property since March 31st. He's not even in a position to file such.
So is it our, for my sake, I guess, Mr. Let's just stick with Gordon McCain. Gordon McCain, are you on property that you've got a notice that they've terminated your interest in it?
Yes, I've had things sent to me in the mail, but I just don't have the finances to catch up. And as you see, he's opened up my mail, which he shouldn't be doing.
Are you still on the property?
Excuse me, sir?
Gordon McCain, are you still on the property then?
No, I left. I've been staying out of my truck for a while.
Oh, so you're not even on the property. I'm assuming there was an eviction. Is that what happened?
No, not at all.
No eviction.
No eviction notice
for either one of you. Hold on. For either one of you.
Pardon me. Mm-hmm.
I'm trying to get him evicted because I'm like he just said, I'm losing the house because of back taxes, but the property's still in my name, but it's fixing to go up to auction on September 5th, and there's nobody buying it.
That's what I was going to ask next. So it's a little premature. You still have the property.
Yes.
No, sir. I have an actual paperwork.
Brian, hold on, sir. You keep interrupting me, man. I'm going to keep you. Next time, don't unmute until I tell you to, okay? Because quite frankly, it sounds like you can't keep your mouth quiet. Gordon, so this is your property. It's in your name.
That's me and my wife's name.
And just to be upfront with me, it sounds like there's a tax issue. Is that true?
Yes.
And
yes.
They've given you a notice that it's overdue?
Yes, and I just don't have the money to catch it all. To catch up on my disability.
And the court hasn't issued an eviction or anything at this point. Is that true?
No.
There's been no quit claim or any other warranty deed or anything else that says that you no longer own it. Is that right up to now?
No, they just been sending me back tax papers, want me to pay it, and I just can't pay it because I'm on disability, and I just don't.
Okay, but so there's nothing that says you no longer own it. Is what you're telling me?
No.
Okay.
As far as I know, because I've not got a hold of any mail. My brother's been collecting my mail, so I hadn't even been to the house to collect my mail. Just trying to keep the peace so we don't get in an argument.
Okay. All right. So, Brian, why don't you unmute now?
Thank you, sir. I appreciate it.
What paperwork were you trying to show me? What's this?
Read
off the top of it for me, if you could.
Off the top of it says, notice of foreclosure of property for unpaid property taxes. You are hereby notified that on March 31st, 2025, property located at 3275 Augusta Street, it's been foreclosed on. The Genesee County Treasurer now owns that for non-property of taxes. That's officially March 31st, 2025. That's from the Genesee County Treasurer themselves down on Beach Street. He no longer owns the property, sir. I just don't want him lying to you. Pardon me with the interruptions. I didn't mean to be that type of an intrusive individual. That's my apologies. I just don't care for liars.
So how did you get that paperwork?
Because I have paperwork that comes to me as an occupant. He's been more than welcome to come pick up his mail. I've sent him numerous texts. You're more than welcome to come through. He since has been able to pick up this or that. A lot of this is just him carrying on with lies. He could be way more truthful. He definitely has had this. You can see I have not opened his mail. Have not opened. This is addressed to Gordon himself. This is from the Treasury.
But
and this
it's probably got.
Go ahead,
Has
sir.
it got something on there that says? I understand it's saying it's foreclosed on. Is it telling you as well on there that he's got a right to redeem the property within a period of time?
What is going on now is you may soon receive a notice to quit, which is the first step in the eviction proceeding. This is from the Genesee County Treasurer. The property may be later sold within the next few months for the money that is owed.
Yeah. So both of you are correct, but he hasn't actually lost it. Yeah, he's got some time to regain interest in it. Sounds like so. So why, at this point, for your sake, Brian, why, are you still on the property too?
Yes, most certainly, sir.
So why aren't you moving?
It's not that I'm not choosing to move. Over the next couple months, I can move with no qualms. He knows I have a water settlement that's coming through the Flint water crisis. Him and I talked about catching up the back taxes. He knows I would have been more than willing to help him with such. Flip side to that, he also knows I was working at Lids as an assistant manager. I now have work with a tree service, and I'm also hired into a pro shop over at the golf course on Hammerberg. That's the Flint, Swartz Creek Golf Club.
Okay. And it sounds like he still has the property though. Granted judgment to Gordon McCain, order that you have to be moved within 10 days, May 9th.
I appreciate the heads up, sir. Thank you.
Okay, sure, you're welcome. All right, both of you, good luck to you.
Thank you. You take care. I'm sorry you
All
even
right.
had to bring this
All right.
drama into your courthouse. Take care.
Oh, thank you. Thanks. Bye.
You're welcome, sir.
Bye.
Oh,
Mr. McCain, you're all set there. We'll send
All
you a
right, thank
copy of the judgment, okay? All right.
Have a good day.
All right, you too.
yikes. Passive aggressive much? Oh, he was angry. He was angry. All right, it's over though. He's got to move. Doesn't sound like he's gonna be keeping the property anyways. All right, let's move on to the last case. Yeah, all I'm gonna say about this case, well, besides this is Judge Ricke, and we like Judge Ricke. He doesn't mess around. He doesn't hold back. He says everything that he's thinking, and let's just say this defendant can't stop talking. From the second the hearing starts to the till she walks away, she's just running her mouth nonstop, and it's hilarious because she doesn't make any sense, and she just keeps running that mouth of hers. All right, you guys ready? You guys ready? Judge Ricke, let's go.
Might this be April Lynn Lyman?
Yes, Your Honor.
April Lyman, you want to face me? But I have the officer in charge to try to motivate April Lyman to face the court. All right, April Lyman, do you respond, please? Apparently, she's not going to. This is State of Kansas versus April Lynn Lyman. It's case number 2024, CR 396. April Lyman, silent as she is, appears at the Butler County Detention Center Zoom location. Cheryl Pierce appears on behalf of the state of Kansas. I will note, docket notes would indicate defendant pled guilty to possession of marijuana and possession of drug paraphernalia before this court back on March the 4th.
Savannah, thank you so much for becoming a new member. Welcome to the family. I appreciate it. Thank you. That is awesome. She's crashing. Yeah, she's crashing on something or no idea. By now you can tell that I was joking. It's kind of funny though, watching her, watching Judge Ricke struggle through this yeah, she does that the entire time.
Has there been an action taken on her sentence by a warrant to show cause, Ms. Pierce?
Yes, Your Honor. It looks like there was a warrant to show cause.
I do not have that document before me. Maybe it was very recently filed. I don't know. So what are the allegations of the warrant to show cause?
So it looks like it was filed on April the 21st. It looks like it's failed to report as directed, failed to make monthly payments, failed to complete a drug and alcohol evaluation and follow the recommendation, and failed to report immediate or failed to report law enforcement contact immediately or the next day, and failed to report all changes in address. It goes on to say has not reported, has not made any payments, not provided any proof of drug and alcohol evaluation, has had a law enforcement contact and failed to report that, and has failed to keep her address current.
All right. In short, after you've read off those allegations in the warrant to show cause, it would appear, Ms. Lyman, that it's alleged that you haven't done anything that you were supposed to do on your probation. Further hearing will need to be set in regards to these allegations, however, before this court. This court's next docket for that purpose would be June 6, 2025, 2:30 p.m. You are required to fully participate in this court's docket at that time. June 6, 2:30 p.m. If you do make bond, you must appear for court at the Butler County Judicial Center in El Dorado, Kansas, and no other location, and report to your officer as directed between the time that you make bond and the time of the hearing. Mr. Lyman, are you hearing, Ms. Lyman, are you hearing anything that the court's saying here?
I believe she is, Your Honor.
Ms. Lyman, what game are you playing here? Because it's not helping you. All right, let the record reflect that Ms. Lyman has just turned away from the court, refuses to respond to any statements or questions asked by this court. What was the bond established on the warrant to show cause?
$2,000 cash or surety.
Just given the defendant's total reticence to even cooperate in any way with the court is going to raise that bond in this case. I think she's a much greater risk than originally anticipated. Court will raise that bond to $10,000.
No, I don't think I did. If I did, I forgot about that. But man, yeah, I'm going to recuse. I need the judge recuse. I need to get Judge Ricke. Oh man, yeah, not good. He's going to read that and be like, "Why did you recuse her?" And then, oh man, Judge Ricke's awesome. He's a very good judge, but he is a no BS judge whatsoever. He doesn't put up with anything. When he gets a soft sit, it is hilarious how quickly he shuts them down. He does not play games. Nothing. He is not there to make friends. He is there to do his job, and that's it. And I love him for it.
Cash or professional surety required. The court just perceives an utter lack of response by Ms. Lyman. No explanation for it. She doesn't report to her officer as directed and really hasn't done anything, as the court noted, on her probation. A considerable risk of flight exists in this case. Court has no confidence that she'll appear for court when directed to do so. So I want to have a substantial bond backed by a surety if she does get out. Our court date again is June 6, 2:30 p.m. Court will appoint a lawyer to represent Ms. Lyman. Darren Patterson will be appointed. We've set our court date, appointed counsel, and the bond has now been reset by the court. I'll ask the question, though I expect to get no response. Ms. Lyman, is there anything else that you need to address the court about? No response as before. Ms. Pierce, anything further at this time?
No, Your Honor.
The April Lyman matter will be in recess at this time, and she can be taken back to her cell.
All right. I know. We could barely get through that. I don't know how Judge Ricke got through that case with her constantly interrupting. I have no idea. None. Vic, thank you so much for the Venmo. Oh, the trip on Monday, but I appreciate that. I don't know if it's happening, but I mean, I guess now it is. Vic, thank you so much. I do appreciate the Venmo, and everyone else who's super chatted, gifted memberships. We have C-Rex, thank you. Carla, thank you. Phil, thank you. Sparkle Poots and Savannah, thank you all. You guys are awesome. Well, I mean, that's the end of the show. That is it. Thank you guys. I appreciate it. We are set up to raid KFAR on Booze and Body Cam tonight. So we have KFAR, KDZ, Lone Wolf is live right now as well. Hold on, let me see who else is live. Was it just those three? Yep, just those three. That's what I got. So you can go hang out with any of those three. I have it set up to raid KFAR. Whatever you guys do, have a great night, and I will see you guys tomorrow. Yep, that's it. And until next time, bye.
Could we get Mitch Pinkham in here next? That's possible.